following acts and committed as a part of a widespread and systematic attack against civilian population with the knowledge of the attack, rape, sexual slavery, enforced prostitution, forced pregnancy, sterilization, any form of sexual violence of comparable gravity. I mean, it is of comparable gravity, therefore it would not apply as a crime against humanity.
Because it's not comparable, yeah.
If you consider it as a war crime, it means that the court shall have jurisdiction in respect of war crimes, in particular when committed as a part of a plan or policy, as a part of a large-scale commission of such crimes, which I think it's what we're dealing with here. And then B, other serious violations of customs applicable in international armed conflict within the established framework of an international law, namely any part of the following acts. And then we have the 22nd point, committing rape, slavery, enforced prostitution, pregnancy, and then like any form of sexual violence also constituting a grave breach of the Geneva Conventions. And if you look up the Article 27 of the Geneva Convention, you have, of the Fourth Geneva Convention, you have that women shall be specifically protected against any attack on their honor, in particular against rape and enforced prostitution and any form of indecent assault.
Indecent assault would cover.
So basically you have that the Viscount is a minister of state in charge of a military command, therefore being in charge either completely or significantly partially of the security forces of his country. The incident happened in a hotel zone within the active hostilities, giving no doubts as to whether the court will have jurisdiction over this case. The Viscount action towards the victims constitutes sexual violence, given that the victim did not consent to the perpetrator's advances, and although it is not clear how local laws define sexual violence, the Viscount's action would constitute a war crime in international law standards, right? And then there's the Rome Statute, that's the Geneva Convention article. And then notwithstanding his position as Minister of Defense, it is customary for immunities to, in principle, not be available before international criminal tribunals. In the arrest warrant Democratic Republic of Congo versus Belgium case, before the International Court of Justice, it was noted that the immunity ratione personae of incumbent office holders could not be used as a way to create impunity regarding the acts of those same individuals, being thus acceptable for international courts to prosecute said office holders, given it has been given the jurisdiction. In the same light of thought, the prosecutor versus Hassan al-Bashir case of the ICC considered that one of the core goals of the